another message from me to you. Now, I want all of you to understand something so that you get what's going on. We know that when we walk into the court, when we walk into the building, the first thing we do is we give consent.
How do you give consent?
Because you walk through a metal detector, and because there is no law saying you have to go through that metal detector, you thereby, ergo, give consent. So, what must you do? Say, yes, I will come through your metal detector, but I reserve all of my rights. Just that simple, people. When you walk into the court and that idiot calls the name of the corporation that you speak in behalf of, you say, yes, I am here in reference to that matter, but I reserve all of my rights throughout. Just that simple, people. It's time for us to get control, to gain control, to re-control, not be controlled. There's a lot going on. So, what I want you to do is compare what you hear here to what you're hearing out there. And notice, nobody is bringing up any of these points. Not one single person. So, we are the puzzle descramblers. We are the puzzles putter-togethers. We are the people who are seeking to find the answers with the clues we have in front of us. We don't want followers. We want people who are there who are going to help us. Are you going to help us?
Ladies and gentlemen, gentlemen and ladies, ladies and gents. In the background, like I said, some people been, the music is too loud. Well, I think the music sounds better than I do. So I'd rather you be able to hear the music, but we've adjusted it so that you can hear me and the music. As a matter of fact, let me turn up the volume, turn up the volume, turn up the volume, turn up the volume, dance, dance. Okay. Now we're going to readjust the music. All right? In the background, we're playing Wars. Why can't we be friends? Well, most of the reason why we can't be friends, ladies and gentlemen, is because there's too many of you, and I'm not looking to have that many friends. Too many. Okay. A lot of information to go over today, and we're going to cover it in a short span of time because we want to get it over to the internet so that many of you can have access to it. Again, the California event is still on, so we're preparing for that starting this week and next week, putting our info together, all of the recent info that we've gathered. Now, please understand, when we say recent, we mean extremely recent. For instance, we've been asking a question. How is the court creating joinder? What do you mean by joinder? How are they joining you to the case? You're not part of the case. So how are they making you part of the case? You know, that's kind of interesting. I was wondering about that myself. No, you wasn't. Yes, I was. I was asking Betty the other day, hey, Betty, how the courts are sitting up there and joining us to the case? And Betty said, you know, dear, I don't know. So I was thinking about, no, you wasn't. Yes, hey, Betty, will you tell him? You know, dear, no, I won't. See, there's Betty right there. Okay, so, ladies and gentlemen, this is what we have deduced because it makes perfect logic, which makes perfect sense. If it doesn't make logic, it doesn't make sense. What is the first thing you do when you walk into a court building? I don't know. Well, let me tell you what the first thing is that you do. When you walk into the building, there's a metal detector right there. And you proceed. Proceeds? We're not talking about proceeds right now. No, I said you proceed, not proceeds. Oh, you're talking about one of those words that are spelled similar and have different meanings. Yeah, well, we're not talking about that right now. We're talking English and we're talking about a situation. Well, go on then. Okay, ladies and gentlemen, here is the facts that makes logic. When you walk through that metal detector, because there is no law mandating that you walk through a metal detector, you are thereby consenting and thereby waiving your rights by such consent. So, what I would suggest you do is make up small business cards. Reservation of rights business cards. We would do it, but we just don't have the time. Now, we have our ID that we hand to them, and they just don't get it. But basically, you let them know that I'll walk through your metal detector, but I do not waive any rights in doing so. I do this of my own free will, deed, and act. Really, it's just that simple. When that idiot sitting behind the desk in the black robe, that robe does not signify that he's a judge. That robe signifies that he is let's just say a master of a particular art. Okay? The robe does not make the judge, and there is no law saying that judges must wear a robe. Do we fully understand that? Okay? That is not a uniform. Nowhere on that robe does it say that idiot is a judge. Some people are going to argue about that. Some people are going to say, no, it's been determined in this case, in that case. Yes, but it hasn't been determined in law. And that's where we're going to go off of from now on. So when we reserve our rights, we also mention to the court, no matter what court you're in, if it's small claims, if it's county superior or a county circuit or whatever county court you're in, or whether it's in a federal court, you make sure that they fully understand that you are one of the people. You are one of the American non-citizen nationals. And sorry about that picture, guys. I haven't gone through all the pictures, and I'm not into displaying things like that. That is, what is the word for it? Suggestive. But that's what happens when you download what do you call that? Background shots, wallpapers. I download wallpapers and I do them in bulk. And I haven't had a chance to go through all the wallpapers because I really haven't had a chance to go through much these last 2 days. Been trying to recoup. But let's get back to the court situation. There is no law, and so we let them know that as one of the people, non-citizen nationals, we do not sit under the law, we sit above the law. And that is supported by the 10th Amendment of their Constitution. Ergo, any laws that are not derived from the people, by the people, or retained by the people. Okay? So we have rights. And we are not going to sit back and just simply allow them to take them away. Is this going to stop them from doing all the stupid things that they do? No. And we're not concerned about the stupid things they do, as long as we note it on and for the public record that we are reserving our rights throughout. I told you all that I've been working on a case. Many of you know the person. And what they were doing to her didn't make any sense. I kept telling her and everyone else who was concerned about the case, because everybody was given their 2 cents, and I told her to tell those people that although they may care, to stay out of it, that I knew what I was doing. You see, I go at cases 2 ways. One, to raise up every issue that is appealable during the matter. So I bring up everything that's appealable, every appealable issue, every right that is violated. I bring that up in advance. The second thing I do is I figure what the personality is of the judge. If he's a mean person, if he's a nice person, if he's a reasonable person, is he a fair person, is he argumentative, is he looking to cause harm? I look for those things. Then I also figure out, does he have a lot of pride? Does he have a lot of ambition? Is he sitting up here trying to flex his muscles because he has a little bit of authority? And as I examine the person, I then realize how to proceed with that person. So this particular judicial officer was the senior chief criminal judge. And as the senior chief criminal judge of the court, this particular officer was sitting up there causing this woman a lot of problems, getting an attitude, yelling and screaming. So what do you do with a kid that is acting out, that is acting like he's better than everybody else and won't listen to nobody? You go, you tell daddy. If daddy don't listen, you go tell grandpapa. And if grandpapa don't listen, oh God, then you go tell grandmama. But he gonna listen to somebody. So the first thing I did was I did a notice of injunction and stay pending the outcome of the injunction, just to bring all of the issues to the attention of his brethren, because we know they're practicing masonry in the courts. But anyway, we'll continue. The next thing I did was I knew that that particular Supreme Court was going to deny that motion. That's okay, because I needed to go to the Supreme Court, who was going to refer me to the appeals court, which is exactly what they did. So I went to the appeals court and they denied it. Guess what they just did? They just told me I exhausted all of my lower court remedies. Now I can go to federal court, which is what we did. The federal court remanded it back to the state court. It's okay, because we knew they were going to tell him to get some act right. We knew that the Supreme Court was going to tell him to get some act right, because now they're all accomplices in what he's doing under failure to act and failure to prevent. And I brought those points up as well. Now, don't all of you follow this, because that's the problem. What I'm trying to tell you is this was one strategy that was utilized for the situation, because of the situation. Well, at first he was yelling and screaming. This was March 29th. I saw the spit coming out of his mouth because of him trying to be agitated. And I sat there and I did not raise basically an argument or a defense or a objection to his ignorance. I did it with his brethren. I then took the original indictment, got it certified by the clerk of the court as an original, got 4 copies of that. I sent one to the Attorney General for the state. I sent one to the court. I sent one to the U.S. Treasury, and I sent one to the Secretary of State for that state. And I paid all of them to the United States Department of the Treasury. Now we're paying it paid to the order of the United States Department of the Treasury, 1789. Remember that phrase. Let me make sure of that phrase so that all of you get it. The United States Department of the Treasury, 1789. Okay? Why the United States Department of the Treasury, 1789? What that got to do with anything? That has everything to do with everything. Because that is the official United States Department of the Treasury. We believe. And we firmly believe that. Why? Because we have UCC documents where that's how they put their legal title. See, what most of you don't understand is a UCC filing requires the legal name. Legal title. And that was how the U.S. Treasury listed themselves. And so, because they listed themselves that way, they let us know exactly how we should be communicating with them. So now we're paying everything payable to the order of the the United States Department of the Treasury, 1789. I'm sorry, you guys are not supposed to be looking at a wine bottle. We're supposed to be doing the random thing. Okay, there we go. So you go ahead and be mesmerized. All right, and I sent that to all of those agencies. Well, we didn't hear anything back from any of them. But less than 7 days, she was being released because they had arrested her on a contempt charge. What was the contempt? Well, they didn't explain. They didn't tell her. They just arrested her, held her in jail for 30 days. And after the 30 days were up, which is right about the time that all of this paperwork went in, they released her. No words, no reasons, no whys, no court dates. They even scheduled a court date, this was in April. So there you are, March 29th, and on April 3rd, they arrested her. On April 13th, they released her. Now, on April 12th, the 13th is when they had a court date scheduled. And at that particular court date, what was supposed to be discussed was the probation, because they put her on probation. Probation? Yes, because they said that she violated a court order. You see, what she did, and she had every right to do this, she followed Corey Ives' suggestion. Corey said, hey, take a picture of the driver's license, label it as the defendant, put it in evidence in the court, surrender the defendant to the court. What I do is something different. I say, here's the defendant. You now have custody of the defendant. Take care of them and return them in the same condition that they were delivered, or you'll be held personally liable. Well, when they released her, no court dates. Not a single court date. Months went by. We had March 29th was the last court date. We have April, May, June. All of a sudden, June 29th. 4 months later, they have another court date. This court date is for the court to determine whether or not she should be held in contempt for filing the secured party creditor paperwork. Now, I don't advocate the secured party creditor paperwork in a criminal matter, especially while the matter is ongoing. That should already be on file prior to that matter being discussed, ex post facto. But we're not going to talk about that right now. The judge was not too happy. So we put together, I made her write the petition. And I can't call it a petition, a presentment. Look at UCC Section 3, Article 501. Article 3, Section 501. UCC Article 3, Section 501. Payment and presentments. We present things to the court. We are the presenters. Introducing the presenters. That's who we are. No more motioning the court. We don't motion the court. We don't petition the court. You see, to petition someone means that they have authority or exercise authority of you. Now, we also do not put any documents in any state court. So at the top caption, let's open it up. Got to keep holding on, y'all. Got to be very strong to keep holding on. All right. See, it says conduct prejudicial to the presenter, reconsideration of an unlawful mandate, presentment rebutting presumptions. All right. But we are the presenters. When you put a case, and this is an actual case, just something they decided to move it to the from small claims court. I was suing the United States Postal Service, and what I was doing was proving that the United States Postal Service is not a government agency at all. So I filed a complaint in small claims court. At no time did anyone say that that was the improper jurisdiction and the case should be dismissed. What the attorney did, the United States Attorney's Office, is they had it removed to federal court. I immediately did an amendment of the complaint, which was my right under law. And I amended the complaint and filed it in the United States District Court in and for the territory of New Mexico. Now, of course, they knew exactly what I was doing and they didn't appreciate it. Well, the court decided that it was going to order the defendants to respond to the amended complaint. They never did. And then 2 weeks later, out of the blue, the court starts saying that the amended complaint is gibberish, unintelligible. It is nothing but a piece of garbage. So I told the court, when you went over it before, it wasn't a piece of garbage. But now, 3 weeks later, it's a piece of garbage because they're in default. And I've requested a default judgment. It's one of those things, again, it wasn't a case I was concerned about. As a matter of fact, the whole removal process happened at the same time I had to respond in this young lady's case. Well, after the hearing on the 29th, after trying to get the public defender removed from the case, and she had been trying since June of last year, I requested that the public defender be removed starting in November. Then December, the public defender had an ex parte communication with the court. That's a no-no. Then we caught them lying on the public record. That's a no-no. So what happens next? Well, the public defender gets removed from the case. Initially, they made him as standby counsel. Then we got him permanently removed. And so the court scheduled, because we mentioned to the court that in the state of New Mexico, the law says that the individual, if they are not giving a trial date within the 365 days, a year, it is considered denial of the right to a speedy trial, which is stupid because every other state has 6 months. Okay, well, it had been a year. And at this time, it was now July. And we put that before the court, and we demanded that the court show cause. Well, the court had another hearing. They scheduled the trial date for October 10th. Now, this was the angle. I told her, don't worry. In the month of April, when she was released, and they didn't have any trial dates, I said, don't worry. We don't need to file anything. Everything is going exactly the way it should. Because they were running out of time. And they would have no time to schedule a hearing. If July came and went, they would have no time to schedule a hearing because they schedule all of their trials during the fall season. And the unique thing about the fall and winter season, too many holidays to work around. That's why you don't see a lot of people having trials and going to court and all of this stuff during the winter time. It just doesn't happen. The courts are too crowded. I said, and they schedule these hearings and these trials during this period. They do the lighter cases during the winter time because the judge doesn't want to have anything on his mind during the winter time because he wants to relax, kick it with the family, go play golf, go kick it with the doctors and the lawyers and the architects. He wants to be able to kick it with his buddies. So I told her, I said, don't worry. It's all going to be okay. Well, she worried and filed those documents, and that pissed the court off. So they decided that they were going to schedule a hearing and asking her to show cause, or they were going to hold her in contempt. And by the way, once you get held in contempt by a judge, the only way to get out of contempt is by that same judge. So the first thing we did is we wrote a presentment to the court apologizing to it for the misunderstanding, explaining to the court that those documents that it received was given in a private, and based on Lanier versus I know I must have that in here. There is some information in here that is incorrect. And so we have to redo this. Okay, so that's why it hasn't been sent out yet. I'm looking for Lanier versus the United States, 1979. That case basically said the court must be given judicial notice. Nope, don't have it. Okay, well, we're going to go back to do that, and then we do that, and then we do that. What happened next was quite interesting in her case. What we did is we told the judge that it had to provide proof as to the contempt, as to the violation of any court order. And of course, the court could not provide that and did not. They barred her from filing any further documents in the court. I wasn't concerned with that. What I was concerned about is, let's go through this with this trial. You guys want to continue the trial thing? Let's go. So they still scheduled it for the 10th. The 10th came and we prepared. This was a case of someone going back into their home after a so-called foreclosure, unlawful foreclosure. And the person went back in their home 3 times and was arrested 3 times. So that's what this was about. On the public record, she's still listed as the owner of the property. And what I'm about to suggest she does is what is the name of that? Quiet title. Since she's still listed as the owner of the property and can prove that FHA insured her home. She can prove this. And the people who are there now, sorry, que sera, sera. Okay. What happened is, our angle was the court was not going to allow certain information to be brought into the case. So what we're going to do is we're going to get them to mention the information. We're going to get the officer to testify that he had a presentment, a writ of assistance. We're going to get him to admit that. Then we were going to ask who signed that order, and the officer was going to tell the judge's name. And we were going to subpoena that judge into this case. And we were going to have that judge state whether or not at the time of her signing that she was not working for a private organization, a private corporation, but she was in fact acting and operating as a judge, which she could not do under oath. We knew that they were recording our call. We knew they were recording our conversation. And I told her, that's what's going to win this case. And I told her, as I told the other person that we conference with, I am a genius. I said, this is genius. Now, mind you, I want you all to understand, it's not that I'm cocky. It took a lot of thought to come up with that angle. And when we did, and I knew they were recording the call, I knew that they would try to get that kicked out of the case. So what is the first thing they did on the 10th? They brought up the writ of, what was that? Assistance. And when they brought up the writ of assistance, these poor idiots, when they brought up the writ of assistance, it was not the same writ of assistance that they had delivered previously 6 years ago, because this case has been going on for over 6 years. And she noticed that it had not been part of the discovery. And they did not try to hide that fact. Ladies and gentlemen, they purposely made that the issue of this case. Purposely botched the evidence so that the court had to dismiss all of the evidence. Interesting, ain't it? That they would purposely do this? And basically, because they had no evidence, they had to withdraw the complaint. And the case has been dismissed. Now, it hasn't been dismissed with prejudice, but here's the problem. Delayed prosecution is their issue because this happened 7 years ago. They cannot prosecute it this time, even if they wanted to. Okay? And then we get them for malicious prosecution and so many other things. So, what I wanted to let all of you know I'm not helping anybody else with any more cases, especially criminal. Why? Because it takes too much time and I take them too personally and it takes too much of my energy. That case has drained me of a lot of energy since November of last year, almost a full year, and letting that be a primal concern. But that young lady who is in her 60s and her husband can now relax a little bit as a result of this case now being over. I have people out there who want to challenge my abilities, who want to challenge my record of handling court cases, who want to challenge the angles I go at, who want to challenge the directions I go at. People, I know where I'm going to end up. I know I'm going to end up in somebody's jail cell. It's okay. I've already anticipated it. I am prepared for it, and I can handle that. The problem is, as we did in the October surprise videos, we're trying to tell you, you can't handle that. And don't sit up here and try to be macho or try to have pride and say, oh, yes, I can handle that. If you can do it, I can do it. Equal protection of law, mother. Okay, please don't do that. You cannot handle it because you're not prepared to not be able to keep everything you have. You're not prepared to lose everything. I am more than prepared to lose everything that I have. That's why I've walked away from what I've owned at least 3 times in my life and started over from nothing and always achieved back to where I was when I started. It's just this time I don't have any ambitions of achieving what I just left. Yeah, y'all know it's true. Okay, let's get back to the other information that many of you are not aware of. We're walking into court and we don't know what we're doing. Well, first of all, you're going to reserve your rights. We're going to be redoing the Declaration of Executorship, okay? We're going to be putting in all of the information regarding the trusts that are multiple trusts. We're going to be putting in all the information regarding the accounting. You see, we told all of you, we understood why the Treasury put a lien on the Fed. And while the Fed was buying $30 billion in mortgage bonds, we told you that they were buying those mortgage bonds to help pay or have money once the dollar plummets. Remember, they receive 28 trillion dollars from the United States government. The banks did $28 trillion, and they were allowed to fractional reserve that $28 trillion. Fractional reserve by 33%. 33%. That's right, 33%. That's not like 33 degrees. 33 degrees. Yeah, masonry. Of course it is. $660 trillion. Now, I said it before. Just imagine if you had 660 trillion ink pens. How much could you sell one ink pen for? Now, I don't want any of you to hurt your brains because I want you to get what's being said. 660 trillion, there are only 7.5 billion people on the planet. So how much could you sell an ink pen for to 705 billion people? You're saying you couldn't. You're absolutely right. You wouldn't be able to sell them at all. You'd have to give them away. That's the situation with the dollar bill. 660 extra trillion dollars out there. Not to add, we're not even going to add the 14 trillion they claim that the United States is in debt with as far as their national debt. Oh, no. It's a whole lot more than 14. We're not even going to add that junk in. We're going to keep it at 660 because Adding anything else to it doesn't make a difference. Ain't going to change nothing. So there's too much out there. There's way too much out there as far as dollars. So the Federal Reserve had no other choice because the dollar will never recover. That's the reason why they did it. The dollar will never recover. So what does the Fed do? The same thing the banks and everyone else is doing. They're buying T-bills. See, that's the unique thing about the Treasury. Its bills, its bonds, it's going to maintain their value. Okay, they're going to maintain that value because without that value, the country does no longer exist. And these men no longer have power. And remember, that's what they're interested in is power. It's all about the power. It's all about the Benjamin. No, it's all about the power. Okay, let's continue. All right, so now we got the understanding of the Fed and the Treasury and understanding why the Fed did what they did. We're going to give you a more detailed explanation of why the Fed is buying $40 billion worth of mortgage bonds every month indefinitely. Because they know that their dollar is worthless. And by buying the bonds, what are they doing? They're paying down the debt on that lien that the Treasury filed against them. You get it? So do I. This is what's going on. Now, ladies and gentlemen, we are aggressively and actively putting the Redress Right organization together. The Legal Redress Commission has decided and implemented a plan. We will be securing people's homes within the organization, within the trust, protecting their homes. Our intent is not to cloud the title. Our intent is to make sure that the title is free and clear of all encumbrances that are unlawful. We are in the habit of saving people's homes. We don't have a figure on how much this is going to cost in the interim, but we do know that it will not be expensive, and we're also going to be working on a plan to acquire people's homes who are upside down on their mortgages, who owe more on the mortgage than the actual house is valued at. We will come in, we will assume the loan, and we will take responsibility for the paying of that mortgage. We will allow the individual to stay in their home, and we will remodify the mortgage at the fair market value at a 0% interest rate, and where the monthly payments will be less than $500 a month. There is no bank out there that would ever do something like that because they wouldn't make the money that they've been making, and they wouldn't be, it's too much junk going on out there. We know that people need relief, and so we're actively seeking to give them relief. And 0% interest, well, although the idea of this came from individuals who weren't really thinking of the scriptures, but when you lend to your brother, he shouldn't be charged interest. And so we are not going to be charging you all interest, and it's not based on the lending to your brother principle, but it will be based on the fact that why do we want to charge you interest? We're not trying to capitalize off of you. Because the Legal Redress Commission is an organization now, we have to acquire capital. And that's why our fees will be reasonable, because we're not trying to get rich off of anyone. But in order to operate in this system, there are a couple of things we must do in order for us to create the currency necessary to operate. And so in the interim, we're going to keep the fees low. And then to make sure that our clients, the ones to be future members, to make sure that they take full advantage, we will not allow them to take full advantage. In other words, we won't allow you to take advantage of us. That's why there will be a fee, because you're going to have to be invested. but you're not going to have to be invested to the point to where you're destitute, to the point to where you have no more money in the bank, to the point to where you're going to have to struggle. You see, I just received a letter yesterday. Let me see if this is it. This is it. Addressed to Brett Jones and the Legal Redress Commission. This is sent from a servicer. This is in regards to one of the mortgages I'm working on. I received it yesterday. I called the individual up and let them know exactly what this response was and what it was related to. Remember, I told you I don't receive it. You can't be. No, we only talk with the borrower and do not bring any more in front of us like this ever again. What do you think you're doing? We don't get those letters. We get these letters. Sorry, I got a cat that seems to try to defy me, and I tell her don't do something, and she does it anyway. I tell her no, and she does it anyway, like a little child. All right, this is what the letter says. The Office of the Consumer Ombudsman would like to thank you for your recent correspondence regarding the above referenced loan. This office will review the servicing of the loan in relation to the issues raised. It is our goal to complete this review within 10 business days from receipt of your correspondence. 10 business days equates to 14 days, calendar days, which by law is all they have. So I don't give up about their policies. This is the law. If the servicing of the loan was assigned, sold, or transferred to our company from a prior servicer, we may be required to obtain information concerning the loan from the prior servicer. And what do they say next? The process in obtaining this information takes time, but we are committed to responding within the aforementioned 10 business day period. Upon completion of our review, we will provide a written response. Look, the Fair Debt Collections Practices Act, the FDCPA, says they have no other choice but to provide a response. We've already contacted the Comptroller of the Currency, which deals with all banks. This is what I do. Most people are not getting these nice little letters. I told you, when I correspond with these agencies, I don't get the ignorance that a lot of other people get. I get the, how do we respond to this idiot? We can't tell him that because then he could use that in court. We can't tell him that because then he could use that against us. What do we tell him? Well, why don't we just tell him nothing? You know what? We're good at that. We'll tell him nothing. So what did this letter tell me? Nothing. It didn't provide any information at all. All it told me was what they're required to do by law. They just documented that they understand the law about the Fair Debt Collections Practices Act. That's all they told me. They didn't say anything else. But they also realized that they are required to respond. A lot of you haven't gotten any responses when you sent out your mortgages. Oh, by the way, they received the new Hour Style money order, and they received a copy of the mortgage. Discharged. This is going to be fun. You guys want to take this trip together? Well, the Legal Redress Commission will be accepting mortgages during the month of November. Please stay tuned to videos as we bring that to your attention and tell you how we're going to be doing this, and we're going to be doing it on a much grander scale. The individuals who did apply for the position that we discussed, please stay tuned because I will be contacting each of you, letting you know the details of that. If you are not one of the ones that I sent an email to saying that I will be contacting you, then you are not one of the ones being considered at this time. So please do not email me asking me about the position because I will block you as spam. Because if you can't listen to simple instructions, that means that you can't handle the position. I know some of you think that's a little harsh, but I am tired of people contacting me about everything else other than what I specifically asked them to contact me about. And so because the emails are based on a subject that I have not suggested I would entertain, you must be a spammer, just sending emails just to be sending them. And I will have to block you because I can't tolerate that type of communication. Okay, like I said, a lot of information, especially the stuff about acquiring homes where people are upside down and still allowing them to live in their homes. Helping people with their mortgages, coming in and assuming the mortgage and then allowing them to pay a small monthly fee as well as no interest. Look, only people with perfect credit get 0% interest. Okay? That is just the way it is. If you ain't got perfect credit, you ain't going to get no 0% interest. Well, we're going to consider all of you to be perfect creditors. Oh, also, there is another plan to help people to acquire credit. Give us some time and we'll work on that. We got something going on. It's going to take about 3 months to implement, but after 3 months, you should have some credit lines on your credit. And remember, starting in November, we are also helping people to discharge items from their credit report to have them completely removed. We'll also be doing a lawsuit against 2 of the major credit reporting agencies for reporting falsified information on a public record in violation of the Fair Credit Reporting Act and the Graham-Leach-Bailey Act. All of these acts we're advising that you do research on. So please stay tuned. I promise you, this is not one of those situations where somebody says we're going to do this and we're going to do that, and they never do. Every day we're working on this, every day, to make sure that everybody gets some sort of satisfaction with this process. So we are aggressively trying to seek a way to get your attention and to get their attention and to bring about a resolution. Thank you for staying with us. Thank you for being a part of this. And we ask that all of you have a very good day as we leave you with In Vogue. Good day. Good night.
We've come a long way, and we got a long way to go. But I want to thank all of you for taking this trip. It's been a journey, hasn't it? We're finding out so much stuff that we would not have found out otherwise. And the fact that so many of you had so many questions, it led us to find out more. We now know that all homes are definitely insured by some insurance company or another, either the Treasury or someone else. But we know these things now. We now know that the courts are looking at us as fictions. And when you walk through that metal detector, if you don't say, oh, I reserve all of my rights, but I will consent to your doing this, but that's as far as the consent go, if you don't do something like that, then you're going to be a fiction throughout the whole time. So we ask that y'all stay with us because we're going to continue to seek redress for no one else but for you.